All right. Thank you very much for taking your time out this morning to be part of this webinar. Just to respect your time, the time is 11 o'clock. So we had scheduled until 12 o'clock. So we don't want to be wasting any time. We will just get right into it. Welcome everyone to the Copyright Awareness webinar. My name is Ole Lwakogele. I am the Emerging Librarian for 2024, and I'm coming from a very beautiful and warm Bloemfontein. Just when we thought that we are getting winter, today's weather was like, no, not yet. You are still in a warm season. So I'm coming from a very beautiful Bloemfontein, and I hope that you're also coming from a very beautiful place, beautiful weather, or just a beautiful day this morning. So today we are going to be getting into the webinar. On the 23rd of April, leading to the 23rd of April, we had a copyright webinar, which was titled Rights, Restrictions, and Responsibilities. And on the 16th, we hosted that webinar. So we thought that it was so fitting that we host a second part of it. And that is because there was so much that needed to be unpacked. And today's webinar promises to do that because we've got expertise in the field of IP and copyright. I am not alone. I am with the team from Nevada. I have got Frida van Wyk, and I also have Mr. Simon. I think he's also going to be joining us in a bit, Mr. Simon Mujapilo. He is the Emerging Librarian for 2023. I also just want to say that today's session is being recorded with your permission, of course. These recordings will be made available on the YouTube channel of Liasa, and it's called Liasa News. So if you missed anything, you can get anything from this session, you can get that from the Liasa News. Or of course, you can also share it with the colleagues that could not join today's session. You can share the link that will be shared later on. And I just want to also say that today's webinar is sponsored proudly by Nevada. Nevada is a sponsor of the Emerging Librarian Award. And of course, we've been having series since the beginning of this year, and this is the fourth session today. So without wasting any further time, we are going to be getting in today's webinar, and we've got three speakers, starting with the first speaker, who is Ms. Maneling Mapike. I'm just going to be reading her bio. So Ms. Maneling is admitted attorney of the High Court of South Africa with over 10 years extensive experience in the legal industry. She is the managing director of Mapike Attorneys Incorporated, a specialist boutique law firm through which she provides legal services mainly in entertainment law, music and film and television, intellectual property law, commercial law, media law, litigation, and alternative dispute resolution. She is the sole director of Yatala Teta Services, an intellectual property law and entertainment law specialist consultancy, where she provides IP advisory services as well as legal training and workshops geared towards educating the creative industries of laws applicable to their respective sectors. So there's so much on her bio, but today I'm just going to be leaving it here, and this is because of time. So Ms. Maneling, you can take over, and thank you very much for honoring this invite this morning.
Good morning. Thank you so much for having me, Xolelwa, and for everyone else from LASA and from University of Free State. So I'll proceed. I do have a screen that I'll share. Let me get it together for you. You know, we just got it right. Now all of a sudden it seems like I'm getting it wrong. But here we go. My screen is on. Welcome everybody, and thank you for joining us. So this afternoon, or this morning, my topic will be on South Africa's Copyright Amendment Bill, the legal implications for academia. So this is just housekeeping. So the topics that we'll be discussing this morning include, I'll do a basic introduction on the bill and where we are, as well as the status of the bill, the key provisions relevant to academia, legal implications for academics, institutional impact on academia. I'll have conclusions, and the Q&A, as I understand, will be done right at the end after all the presenters have spoken. So as an introduction, just by way of background, the original Copyright Act dates back to 1978, and is considered outdated, particularly in the digital era. As you can imagine, there's been a lot of development since from 1978, not only digitally, but in general commerce in terms of intellectual property usages and the like. So our laws are already outdated and need to catch up with where we are. The amendment of the bill was introduced in 2015 to modernize copyright law, especially for education, research, and public access, amongst others. So for the purpose of today, we'll definitely focus on education, research, and public access. However, despite it being passed by Parliament in 2019, the bill has faced extensive delays in becoming law, which will explore what that means for academia and the reasons why it has been delayed. So the status of the bill was approved by Parliament in 2019 and sent to the President, but he referred it back in 2020. And the reason for this was that there were numerous public lobby groups who raised a lot of concerns around, the adequacy of the public consultations, the specific wording that's used, as well as the implications of the wording that's used, particularly around the term called fair use. We'll get into what fair use is versus the South African concept of fair dealings in the next slide. The revised version was passed in 2022, but is yet to be signed into law. As recent as a month ago, the Copyright Coalition did write to the President, and they managed to get the bill removed yet again because of issues around wording. And this speaks more to people within the music and entertainment space. However, it does still apply to everyone who would use the Copyright Amendment Bill and ultimately the Copyright Act. So this prolonged delay leaves both educators and content creators in a legal limbo. The key provisions for academia of the Copyright Amendment Bill are that the bill introduces a fair use doctrine, providing more flexible copyright exceptions, especially for educational purposes. So in our South African law as it stands, we use the doctrine of fair dealings. And fair dealings is a closed list of rights which allow for usage without necessarily getting approval from the copyright holder and or owner. So what this means is that there were five areas where it was automatically left open. It was educational purposes, it was for news, public interest, as well as for reporting. In this instance, with fair use is a wider cast net, which is an American principle or doctrine, which opens the net much wider for copyright owners and holders in order for them to prove the usage, but allows more public access to use of their copyright without getting the requisite licensing. So what this then does is that it requires that the copyright owner needs to prove that there has been copyright infringement and that fair use does not apply, versus where the fair dealings doctrine applied is that you would have to prove that it does actually fall within fair dealings and it leaves it as a limited scope. So this already creates a lot of problems for owners and creators of works, even as academics. If you've written a book and your book is then written, now copies can be made of it, and you have to substantiate why it's fair use instead of it being fair dealing. And as we know, there is educational material that is created and prepared. However, there are still textbooks which are for commercial purposes and are sold as such. And even in places like libraries, you can't just print a copy of a textbook and just, disseminate it or distribute it among students. You have to buy the textbook, this book list. But in this instance, with the fair use doctrine, it would then open that a lot wider, because it says, educational purposes should allow for usage of material without necessarily paying the requisite license fee or buying the textbook that you're required to. In addition, the educational exceptions would allow the reproduction and sharing of copyrighted materials in classroom, distance learning, and for students with disabilities. So this is where the advantage comes in, because there is an advantage and a disadvantage. So the advantage is that if you are able to reproduce copyrighted material, you can share that information and also assist with students who are in more remote areas, also assisting with, from a financial point of view, where students cannot afford to buy, as we all know, in 1 year, in one semester, you at least buying 4 or 5 textbooks. And now, if we do have these provisions, that would then grant the ability for use of textbooks, for printing of those textbooks without necessarily having to get the requisite licenses and or approvals. Libraries and archives would have greater rights to digitize and preserve material, which speaks to the work that you do. And works funded by public money could be made openly available, and which is really important for yourselves as librarians, as academics, for research dissemination purposes. And institutional impact on academia. Universities would need to revise copyright policies and train staff on the new provisions. So already these policies should exist on how copyright is used. I know that with my alma mater, we used to have very clear signs at the law library in particular, where it's specified how you can use the printers and what you can photocopy and what you can't. We had library assistants who would also guide you and assist you. So this speaks to those same kind of principles. However, they would have to speak to the amendments to the bill. There's also potential to reduce costs for course packs, textbook licenses, and permissions. The other thing is that the bill does encourage development and use of open educational resources, promoting academic sharing and innovation. Lastly, libraries could expand digital services, especially critical for remote and under-resourced institutions. So in as much as there are the advantages, there are also the disadvantages. And in this instance, from an academic point of view and educational point of view, the advantages would be far greater than the disadvantages, except where you are, an academic who does draft textbooks, and now you would not necessarily get the necessary license fees that you ordinarily would have gotten. I mean, I'll use an example with my grandfather, who did write textbooks for both schools and universities, and even to date, we still get royalties from the textbooks that he wrote because of the licenses that he has. So we also would be impacted as a family from earning those royalties that he had earned from writing those academic textbooks. The impact in terms of the delay: without the bill being signed, institutions are stuck with outdated laws that don't reflect the digital realities, and therefore they also affect your ability to move with the times, to digitize, and to share content easier. This also creates uncertainty and risk when using content or teaching online and data. So if you're using online platforms, parties who own the material could complain and request that you get licensing because it is an online platform, and the usage then becomes open to a wider net of people instead of keeping it limited, and therefore limiting again the ability to make money. It also does cause delays, and it damages South Africa's standing on IP law, particularly under global treaties that we are a part of. So if our laws are behind, it means that we're consistently playing catch up, and we are unable to equally or collaborate sufficiently with other international organizations, and being able to be on the same playing fields. It also holds back policy advances in digital education and inclusion, which I think we've already spoken about. In conclusion, there are numerous schools of thought in terms of the Copyright Amendment Bill and whether they are comfortable and happy with the usage of this current bill in its current state for it to then be passed as law. The supporters of the bills are the likes of universities, students, libraries, and disability groups. Welcome it because it's more inclusive and accessible to copyright law. I mean, even with disability groups, it even goes to the extent of Braille, that textbooks would then be, and other books would then be reduced to Braille, and those copies in some instances, I mean, there's been differing interpretation as to whether this means that if you're reproducing a textbook into Braille, whether that requires a license or not, or because it's just in effect a translation. So there's a lot of different articles, different disputes and different interpretations. And those who are opponents to it include publishers, the music industry, and global copyright lobbyists who argue it weakens copyright protections and could deter investment. And others call for a compromise and say that maybe the provisions, if they were drafted better, this would provide access, but also protect the rights of creators. So it's a matter of playing a balancing act on the creators as well as the users, for purposes in particular for academia and educational purposes. So in all, the debate does highlight the broader conflict between knowledge access and IP control, as well as rights of other third parties and creators of the IP. And as a way forward, the bill could transform access to knowledge and support academic innovation in South Africa. However, the ongoing delays leave many in the academic sector uncertain and constrained by a legal framework from a pre-digital era. Going forward, a balance is required between rights holders and public interests in education and research. Institutions should begin preparing now as even as we wait for final legal clarity. And with that said, ours from our school of thought, we think, there's no harm in having a copyright law that allows for access, particularly from an education point of view. However, that balancing act needs to be reached where all parties feel as if they are not being hard done. I mean, from an academic and educational point of view, yours might be that the more access you have to material, the easier it is to teach, the easier it is to be flexible within the classroom and teaching. Whereas, the rights holders themselves will feel that the more people are given free access takes away from them earning what they need to earn from the intellectual property and what they have created. So in the interim, our recommendation as well while institutions are waiting for this transition and for confirmation as to whether this fair use doctrine will be used and whether the bill would be passed, is that already processes be put in place that still set confines as to how you use copyright. So the existing copyright policies that you have are still a good basis because they would prevent any sort of infringement. However, once the bill is then accepted into law as an act, then you add on to what you already have and ensuring that the provisions do speak to the bills. And I mean, I think we still have a bit of a long way to go. As I said, the lobby group Copyright Coalition has taken the matter back to the president, and the president has been stalled. I mean, there was actually a court order that was issued to that effect. So this is now a litigious matter that the courts need to deal with. And if anybody knows anything about litigation at this point in time, is that our court rolls are extensively exhausted. And, in a lot of the litigation matters, we're looking at court dates in Johannesburg, that is, we're looking at court dates as far as 2030. So, and we're only in 2025. So you can imagine the kind of delays. However, because of the nature of this, we do anticipate that it would be expedited because it is in the public interest, it is in commercial interest, and it isn't just the greater interest of development of legislation to the advantage of us as a community and society. So that is all from me. I hope I did meet my 15-minute mark, Xolelwa. But thank you so much, and I hope I did share as much as I could there.
Just in time, as I was about to say, just in time. Thank you very much. And of course, as you've said, we are going to be taking all the questions at the end. But if you feel like you want to ask now, you can drop your questions on the chats, and that is where we can just respond as we go along. Also, someone that is going to be speaking more on the amendment bill later on, it is Denise from Recreate. But before her, we are going to be getting a presentation from Dr. Ramika Bansi. Dr. Ramika Bansi is an intellectual property rights specialist, practices as DUT's copyright specialist and lecturer. Her area of expertise is innovation assessment, IP strategy, technology commercialization, and university industry collaboration. Her focus on enhancing entrepreneurial engagement with the goal of fostering self-sustaining academic environments. Her expertise extend to copyright and authors' rights, with particular interest in the commercialization of university research. Dr. Bansi's research included a detailed case study on intellectual property from public finance research by universities, specifically within the South African context. A previous study explored the commercialization of university innovation in South Africa, contributing valuable insight into how universities can better leverage their research outputs for economic and societal impact. And her current research underpins reclaiming humanism in the university management for meaningful purpose, foundational support on how intellectual property management and technology commercialization can contribute to more humanistic and purposeful university management practices. Dr. Bansi, thank you very much for honoring the invite. You can take the stage.
Thank you, Xolelwa. Can you hear me?
Yes, we can hear loud and clear, Doc.
Thank you, thank you. May I share my screen for one moment, but I think many of you would know who I am. Where am I? Okay. All right. Thank you, Zalelwa. Thank you for the invitation to speak, and thank you to the listeners, those that have made the time to attend today. Zalelwa, is it okay that I share my screen at this point?
Yes, it's okay, Doc.
Okay. I beg your pardon, I was on a different screen. Okay, we'll get started. Thank you. So this morning's conversation is going to be about intellectual property rights with a focus on a reflection for libraries, what library staff need to be thinking about, what we should be planning ourselves for. We should have planned already, but also innovation is so fast moving, and we need to always be in the planning stages to make ourselves effective. So when we get started thinking about intellectual property, and I'm going to be referring to intellectual property as IP, is at the core of information management. The evolving landscape of digital content, open access, and complex copyright laws, amongst other law, like the IP law, makes it essential for librarians and information professionals to understand and actively manage IP issues. Now, let's begin with a very simple definition of IP. And when I say simple, I've made it in summary version for what we should be looking at for the purpose of the presentation this morning. So if we look at the definition that I want us to think about during the course of my presentation, is just understanding intellectual property are creations of the human intellect, meaning the mind, and they may come in various forms, and one could be innovation to literary and artistic work that are deemed intangible assets owned by rights holders and are protected by law. The law entitles one to earn recognition or financial benefit from one's creation. Now, this is very important for us to understand, and why libraries' focus on intellectual property is so vital. It is especially so from the point where at most academic institutions, the institutional repository and various forms of manuscripts are being loaned by the library, whether it is an online, electronic loan or a physical loan. These are published material that we need to treat with respect. Now, a lot of what I am going to be discussing this morning comes about from the IP Act 51 of 2008. Now, I know that's a mouthful, but if there is something in IP law that's affecting the type of service a library may render, then the IP Act 51 of 2008 will cover you. There are various points that you could go back to the law and check if clarity is required. Now, not all of us is going to be able to read that IP Act and digest it as easily. So I'm going to brush through the broader concepts by which IP is regulated by the Act. Intellectual property underpins creativity and innovation, serving as the legal framework that protects the rights of authors, researchers, and content creators. Libraries function as stewards of both access and protection, ensuring users can benefit from a wealth of resources while still upholding legal and ethical standards that safeguard IP. This dual role that librarians play, librarians and information professionals, is especially crucial in our fast-paced digital age, where libraries provide access to a vast array of digital and multimedia content. So there are various aspects of the law that has to be considered whilst we, as information professionals, have to give access to our users and to guide them in the most protective way to ensure infringement is not something that can easily be overlooked. So there are challenges that we have to experience, unfortunately, but together with the law, IP law, and most of the policies and procedures that libraries have put in place will help you navigate through those challenges. And understandably, libraries face ongoing challenges in navigating the complexities of the various types of laws, whether it's the IP law and the changing copyright amendment bill that we are still awaiting for. And these laws more especially focuses on managing licenses for digital content and understanding the fair use provision, as well as our previous speaker has alluded to. Balancing the need for broad user access with strict legal compliance requires careful negotiations. Now, we have to negotiate on license agreements, continuous monitoring of user activities, and that helps to avoid infringement. So the rise of digital resources has heightened, and the need for robust copyright management, IP management, and all the other laws that are implicated with the IP Act, and it could also be the Plagiarism Act, within education to prevent unauthorized use and or sharing that constitutes non-compliance. Now, at this point, I want to focus on embargoes. Embargoes is, for those of you that need an understanding on that, is normally levied onto patented work. And we refer to it as an embargo when the work has been completed, the research has been undertaken. Perhaps the researcher has even been awarded a qualification towards that research. But if that work comprises of intangible work, something that emanates, that has value, commercial value, then that type of work will be put into an embargo. An embargo meaning that only if there are funders that were directly involved in that particular research, and the researchers themselves, one or multiple, will be entitled to access that work only during that embargo period. Now, the common terminology that academics normally think about once a qualification has been completed, and it's a common terminology, it's publish or perish. Unfortunately, when you have work that has an embargo pending on your work prior to releasing the results, please understand because of commercial value and the funders may have access to it, that type of information that's deemed confidential, being under embargo, will not be shared to the public within the public domain. So that is something that is regulated also by the IP Act, and I keep repeating, Act 51 of 2008 is an act that you would always be referring to if there's tangible outcome from research work that requires protection, IP protection. We talk about education and empowerment. Librarians are called upon to educate students and researchers on copyright and other IP laws, and always ensuring ethical content usage. So what libraries' roles are is to provide clear policies with advice, becomes critical to assist users navigate IP complexities to avoid infringement. Libraries need to facilitate a good understanding of legal framework, assisting users, especially from the point of being able to navigate the rules of what is permissible in accordance with copyright legislation and how to ethically use information resources. So policies being formulated at the various institutions is of critical importance. The role libraries play is a dual one, promoting access to information while ensuring one and all respects legal rights of content creators. This involves acquiring licensing, negotiating access with on an agreement, ensuring compliance with copyright and other related IP laws is imperative. So we will look at successful IP management and how we can make it a win-win situation for researchers alike as various content creators to come to an agreement where work can still be utilized. So it is important for successful IP management that the library collaborates across various departments at the institution. And the departments I'm talking about would be the legal department, the ITC department, research officers, and administration officers as well. So integrating IP strategies with the broader institutional goals lead to more effective outcomes and foster a culture of innovation that ensures a unified approach to compliance. Now, at this point, I've got to bring back the Act, and the reason we state successful IP management is most effective when a vast amount of collaboration is done with the various stakeholders within your institution. That is important because every step of the way, librarians, postgraduate librarians in particular dealing with postgraduate students, will remember the do's and don'ts and how much of information that needs to be disclosed in the public domain and what information is vital to hold back on, especially if there is potential IP emanating from research work. And that is the reason why publication, the golden rule of publish or perish, needs to be delved into more carefully, because one is never able to publish if you have embargoed work or work emanating into a tangible outcome like an innovation that requires the registration of a patent. So further, embedding IP awareness into daily library routines, such as integrating research support and into information literacy programs. By doing so, we will ensure IP considerations are not overlooked. Librarians do and will always, in a very big way, support open access initiatives and innovative uses of digital content. And that is crucial. There are various licensing agreements and innovative ways in which digital content can still be used while maintaining respect for IP rights. The other point that we always have to remember is leveraging data analytics and technology, including digital rights management, RDM systems, enables libraries to monitor usage and enforce copyright restrictions more effectively. So it's very important on gaining from data analytics that we are able to monitor usage, and that way rights can be upheld more effectively and efficiently, ensuring no infringement takes place. So aside from collaborating with departments internally within your institutions, consider participating with external stakeholders and probably participating in various consortia. This enables bargaining power and knowledge of sharing IP collaboratively, thereby strengthening IP management effectively. Now, I'm going to take a little bit of time and talk about bargaining power and sharing IP collaboratively. Now, we all know and we are familiar with educational institutions having had huge budget cuts over the years. Hence, it doesn't allow a university to easily commercialize work that has emanated from research work and becomes tangible IP that requires registration. Therefore, I am saying it is important to consider external stakeholder collaboration because your bargaining power is heightened, and sharing information collaboratively on various advisory boards and consortia, you would strengthen your ability of managing IP effectively and still generate third stream income, which has become very imperative at most institutions. The generation of third stream income via IP work can be, depending on the type of research the institution undertakes, can amount to huge amounts. And it is common knowledge that most universities are turning to the generation of third stream income from innovation in a big way, and that helps the depleting budgets that we seem to be receiving from government.
Sorry,
Continuous profession.
I just want to let you know that you've got 2 minutes.
Oh, okay, quickly.
Yeah.
Continuous professional development is vital. Stay updated on emerging trends, changes to law and legislation like the Copyright Amendment Bill, technological advancement, and remain effective custodians to IP. Regular training on IP matters is essential, and become an authority with updated, enhanced knowledge. This will enhance confidence and make your IP advisory roles more effective. So the recommendations would be, it's librarians and information professionals are vitally navigating the complexities of intellectual property. By embracing collaboration, continuous learning, and proactive education, one can ensure both protection and content creators' rights and advancement of open access, innovative access to information. And my last slide, I talk about commitment to IP. So I trust my presentation outlined the evolving and essential role in intellectual property stewardship. Commitment to IP ensures knowledge is both respected and shared. Keep leading the way, information professionals and librarians, thereby shaping a brighter future to one and all. Thank you.
Thank you very much, Dr. Rameka Bansi. And of course, as we've said, if you've got any questions, you can just note them down or put them on the chat. And I also love that you just shared strategies for effective management of IP. And I will really be coming back to this presentation, as I said. And as I said, if you want to catch this presentation, you can always refer back to it on the Liasa's YouTube, which is Liasa News, if you want to listen to it again. Thank you very much, Doctor, and we'll get back with questions later on. So our next speaker is Miss Denise Rosemary Nicholson. Denise Rosemary Nicholson has a BA degree and higher diploma and library in information science from UNISA and Masters of Law from Wits. She's a scholarly communication and copyright consultant at Scholarly Horizons in South Africa, which she established in March 2021, and co-founder of Recreate SA. She has worked in different specialist posts at the university at Wits for 38 years, 24 of which she managed Scholarly Communication and Copyright Services Office. She is an expert advisor to the International Federation of Library Association and Institutions, IFLA, and copyright advisor for Liasa, Creative Commons SA chapter, and NCLIS. She's a member of the Academy of Science Scholarly Publication Committee. She's internationally recognized for her professional work and advocacy in copyright, access to knowledge, open access, and scholarly communication. Ms. Denise, you can take over, and thank you very much for honoring the invite this morning.
Good morning, everyone, and thank you very much for the opportunity to speak to you today. I want to thank you for the introduction first. My title is Civil Society's Role in Copyright Reform in South Africa. As you know, the copyright reform process in South Africa has been a long and bumpy road. The genesis of the bill was in 2009, when the Department of Trade and Industry commissioned various research studies and established the Copyright Review Commission to investigate problems in the music industry, especially the failure of collecting societies to pay fair royalties to artists and creators. The Commission's report in 2011 provided the impetus for the DTI to draft a copyright amendment bill. Because the library and educational sectors had been campaigning for years for copyright reform, I wrote to the Minister of Trade and Industry in late 2014, stressing the importance of including limitations and exceptions in an amended bill for libraries and archives, people with disabilities, education, research, etc. As a result, I was invited to meet the DTI's legal team in Pretoria to discuss requirements for research, education, and academic activities, people with disabilities, and libraries, archives, museums, and galleries. I later sent them various documents and resources to assist them in drafting appropriate clauses in this regard, including relevant WIPO treaties and treaty proposals, documents from IFLA, Creative Commons, IFL's model copyright law, and international, regional, and local research findings, as well as progressive clauses from various countries' copyright laws, including the US, EU, Singapore, Germany, and others, which helped to create the framework for the bill. The draft bill was published for comment in July 2015. Sorry, I just wanted to say I apologize if I do duplicate any information already shared by previous speakers. The draft bill was published for comment in July 2015. It had and still has very useful provisions for libraries, archives, museums, and galleries, which will empower their staff to carry out their statutory mandates effectively, especially in the digital environment. The bill also has helpful exceptions for research, education, and academic activities, persons with disabilities, temporary digital copies, orphan works, and addresses open access and licensing, protection of contract override to protect creators and authors when contracting with publishers and other third parties, and has various provisions for giving authors and creators more control over their works. Fair dealing in section 12 of the current law, which is a closed list of permitted acts, is expanded in the bill to fair use in section 12A, which is more open and flexible. Fair use has 4 criteria to consider when using others' copyright works. Fair use is already in at least 12 other countries around the world. Fair use will enhance access to information and future-proof our copyright law as new technologies and development arise. The benefits of the bill do extend to all stakeholders and not just to users. Also, regulation of the collecting societies will enable them to, authors and creators and performers as well, to receive fair royalties. Now, after considering public submissions, the bill was revised and sent to Parliament in 2017. After a contentious passage through the Portfolio Committee on Trade and Industry and the National Council of Provinces with several revisions, the bill was passed by Parliament in 2019, but was not signed by the President. During the entire parliamentary process, there was a split among stakeholders, those that would strongly oppose the bill, including rights holders, collecting societies and multinationals, and those who strongly supported it, including international organizations such as IFLA, IFL, the International Council of Archives, Creative Commons, Education International, the African Library and Information Association, and others locally, representing education, libraries and archives, the open access movement, teachers' unions, organizations serving people with disabilities, NGOs, creators, and authors. So a wide spectrum of people do support the bill. Unfortunately, opponents of the bill formed an alliance and embarked on a media plan to demonize fair use and other exceptions in the bill through disinformation, which caused much confusion for creators and users. This led to the group of supporters of the bill and myself establishing Recreate South Africa in 2018 to counter their disinformation and to ensure that facts about the bill were made available to the public. Recreate South Africa is a voluntary association with a membership consisting of organizations and individuals working as teachers, writers, actors and performers, musicians, authors, artists, film producers and directors, photographers, educational content producers, journalists, software and video game developers, technology entrepreneurs, communities serving people with disabilities and producers of accessible format materials, academics, researchers, librarians, archivists, and other creators and users of culture and knowledge. Recreate is a leading civil society movement in South Africa, working with government and other stakeholders to support the broader copyright reform process, to remedy the apartheid-era anomalies, omissions, and discrimination in the current Act, in the interest of all South Africans. In a project last year, when we communicated with all the copyright officers in Africa, it was evident that civil society participation in African copyright reform is rare. To the best of my knowledge, Recreate is the only organization in South Africa and Africa that represents and has affiliate groupings from both creators and users of copyright works and promotes fair and balanced copyright legislation for all stakeholders. Due to unprecedented pressure from the US Trade Representative's Office, the EU Commission, the US entertainment industries, collecting societies and publishers, the President declined to pass the bill in 2019, questioning its constitutionality in a number of clauses. It sat on his desk for about 15 months, and then he referred it back for a parliamentary review in June 2020. At the same time, the bill was retagged from a Section 75 national bill to a Section 76 provincial bill, which resulted in a lengthy passage through all the 9 provincial legislators in 2022 and 2023. Parliament finally passed the bill for a second time in 2024 and was sent to the President for assent. It unfortunately remains unsigned to date. IFLA wrote an article and said this is the most scrutinized bill in the world because it has had so much attention and so much input. So it's been internationalized as well. Now, Blind SA, an alliance member of Recreate, had already taken the President and other parties to the Gauteng High Court in late 2021, and then the Constitutional Court in 2022, contesting the constitutionality of the current Copyright Act because it has no provisions for disabled people. Both courts ruled that the current Act is unconstitutional as it relates to blind and visually impaired persons and provided wording for Section 13A to be read into the current Act for a period of 2 years in anticipation that the bill would be signed by the President by then. That is by the 21st of September 2024. Unfortunately, the President failed to sign the bill by the 21st of September, and temporary Section 13A provisions fell away, leaving a hiatus in the law, meaning that making accessible formats for blind and visually impaired people was again illegal without permission from rights holders. Blind SA took the president to the Constitutional Court again on the 10th of October 2024 for failing to sign the bill in time and putting blind and visually impaired people in this uncertain situation. 5 days later, the president declined to sign the bill and referred it to the Constitutional Court, together with the Performers Protection Bill, which is linked to the bill, suggesting there were still constitutional issues relating to fair use, exceptions for libraries, archives, museums, and galleries, temporary copies, and education and academic activities. Section 19D exceptions for people with disabilities were not included in this matter. On Wednesday this week, the Constitutional Court made the following findings in the Blind SA matter against the president. Blind SA's application for direct access to the Constitutional Court was justified and granted. Section 19D of the Copyright Bill will now replace the temporary court-crafted Section 13A as mentioned, and this will form the legal framework for government to ratify the 2013 Marrakesh Treaty and will remain in effect. The reason for their application to the Concourt was a direct result of the president's failure to do anything after the National Assembly had sent the bill to him, and his poor communication with Blind SA. And the president was ordered to pay their costs at the rate of 2 counsel. Now, this is a landmark decision and will benefit blind and visually impaired persons and those with other disabilities, as Section 19D includes people with disabilities such as deafness, dyslexia, learning and physical disabilities which prevent or restrict access to information. It will now enable South Africa to ratify the Marrakesh Treaty to facilitate cross-border exchange of accessible formats. We hope this ruling bodes well for the Copyright Amendment Bill matter, which will be heard by the Constitutional Court on the 21st and 22nd of May. Since its inception, Recreate, as a civil society movement, has been proactive and involved in the legislative process of the bill and responsible circulation of information about the bill. It has made many submissions on various versions of the bill and submitted legal opinions to Parliament. It is presented at various workshops and in online presentations in Parliament and in the 9 provincial legislators' hearings. It has attended many events on the bill and has itself arranged many events to inform the public about facts and the benefits of the bill, and countering disinformation about the bill in newspapers, on TV and radio. Some of the Recreates Alliance members also made submissions to the US Trade Representatives Alliance hearings in 2020 to support the bill and to object to its economic bullying and threats to withdraw AGOA benefits if the bill was signed.
Sorry, Ms. Dennis. To interrupt. 2 minutes now.
Oh, golly, I've still got lots. Recreate works closely with many international and regional organizations and institutions, and in recent years has co-hosted 2 high-level international conferences on copyright and related matters. And the Right to Research Conference held in 2023, and the Copyright and the Public Good Africa and the Global South Conference held in February this year. Both conferences highlighted the need for updating copyright laws in Africa and supported the benefits of the Copyright Bill in South Africa. It also included, the second conference also included a half-day post hosted by IFLA addressing library and AI issues. Recreate also provides information and resources about the Copyright Amendment Bill on its website, and I also circulate a lot on my website and via my e-bulletin and resource pages, etc. In the Constitutional Court referral matter by the President, Recreate's amicus curiae, or Friends of the Court application, listed 20 organizations representing creators and users in support of the Copyright Bill. A number of international umbrella organizations for libraries and archives, etc., did not add their name because they felt that they were international bodies, and this is a domestic matter relating to our Constitution. Recreate's role to date has highlighted the importance of civil society being proactively involved in copyright reform in South Africa and the need for it in other African countries. Civil society needs to be part of copyright reform from the genesis to conclusion of lawmaking to ensure balance for all stakeholders. Civil society has a lot to offer to the process of copyright reform, example, expertise, practical experience, research findings, academic publications and conference papers, etc. The bill is not perfect, we all know that. No law is perfect, but it does have helpful limitations, exceptions for creators and users, It also addresses education, research, and libraries, etc. It takes South Africa's copyright law into the 21st century and future-proofs it to embrace new technologies and developments. It also aligns our law with the progressive copyright laws of countries mostly developed that have long benefited from similar provisions in the bill. It is time to level the playing field so that South Africa, a developing country, can also start enjoying such benefits. As an appointed amicus to the court, Recreate, through its legal team, has submitted various documents in support of the bill and will attend the concourse case later this month. There are 8 amici in this matter, all of whom have made written submissions for or against the bill. Recreate is the only amicus that represents creators and users. We hope that the court will make a positive decision on the bill on the 22nd of May, so the bill can proceed with assent by the President, then draft regulations for public comment, and finally a Copyright Amendment Act in the not too distant future. However, it will take at least another year or 2 for systems to be put in place and to commence implementation of the new amended Act. Thank you.
Thank you very much. Thank you. Oh, we're running out of time. Thank you very much for the great work that you are doing and also just coming to tell us on the developments of what has been happening and the work that Recreate is doing. I'm going to be taking very few questions that are pressing. Could you just raise your hand? Apelele, could you please help me with that? Just raise your hand and Apelele will open your mic and then you will be allowed to speak. And please make your question very short, straight to the point. Are there any questions so far? Okay, I think my first question then would go to either Dr. Bansi or Maneling. What constitutes as a fair use? On the last discussion that we had, there was a general perception that the fair use on the current law, it is 10%, but I also just want to find out from you what constitutes as a fair use when it comes to the university or library setting.
Hi, Tolula, can you just repeat that for me, particularly the 10%?
Oh, okay. So I wanted to find out what constitutes as a fair use in the current law for university or a library setting. And that is because the general perception is that it is 10%. So I just want you to clarify that for us.
Look, I think from our perspective in our country, there isn't fair use as it stands in that form of doctrine. So fair use as a doctrine doesn't exist. And I think there is quite a bit of a misconception about how much a percentage of usage, and this goes across the board with multiple forms of copyright, be it literary, musical, and etc., where people have put, some say 8%, some say 8 seconds of a song can be used without any sort of approval. Some will say 10%. I mean, it also just does depend on what it is. If you're using it for reference work, then you have to then still credit and reference it accordingly, particularly if it's an academic. However, if you're going to then write a whole chapter that is based 10% on somebody else's work and it's word for word, line for line, without any sort of reference or anything of that nature, then you would be falling into realms of copyright infringement. So I think people have to be careful in terms of, when we're talking about fair dealings, then fair dealings is saying, from an academic point of view, here's material from XYZ that you're using. The same way when you're writing a thesis, a dissertation, or a paper, or even an article and the likes for academic purposes, if you do then reference and you mention the fact that this is it might be an article based on, someone else's paper where you're responding to it, etc., but you can't write 10% of that article as your own, so it's very important that you're still, we're still applying the basic rules and basic tenets of copyright and copyright infringement, even in instances where the likes of fair dealings exist. So in terms of the usage for libraries and any sort of 10%, that in of itself is also, I think, very up in the air for me. I think I'll hand it to Dr. Ranzi to answer that. But, my understanding and my knowledge and also the issues that we've dealt with is that usage without approval is still an infringement. But in terms of fair dealings, depending on how you're using it, be it in lectures, lecture slides, informational, educational purposes, it can be accepted. So it's just the usage itself and how you use it then could teeter into what is copyright infringement.
Yeah. We unfortunately have ran out of time, but I'm glad that you have shared your details. So anyone that might want to follow up, they can maybe just maybe get in touch with you. And thank you very much to all our speakers. I know somebody is going to be doing the vote of thanks right now. Ms. Frida, I'm going to give over to you, and that is because there's another webinar that is starting and we don't want to take their time. Thank you very much.
Thank you, Kolelwa. And firstly, I'm sorry that I do not have more time to thank each of the speakers individually, because you have done a fantastic job. And for me, it was always a question of what is the real different opinions made of out there. I've got a good understanding of this morning. And I think from my side, I can clearly see that it is and was a problem to get a balance between rights holders and the public interest in education and research, and the impact that this will have on education in this country. To all three of you, my sincere thanks for taking the invitation from Kolelwa. And Kolelwa, thank you for organizing these fantastic, highly academic, informed speakers for us. I thank you and have a nice day.
Thank you. Thank you, everyone. Enjoy your day.